We now turn to the third of the series on alimony. This one we're going to talk about the statutory factors and the theories of alimony in Florida. First of all, the statutory theory of alimony in Florida is that it is gender neutral. As we talked about in the previous lecture, in the case of Orr versus Orr in the United States Supreme Court, the United States Supreme Court said it is unconstitutional to have gender-neutral statutes in alimony award statutes. And the main concept of the theory in Florida, as far as its overriding and overarching feature of alimony in Florida, is that it is meant to mitigate harm. And to mitigate means to try to reduce the harm a party experiences as a result of a divorce. If you read the statute, which is Florida Statute 61001, you'll see that it states that the provisions of Chapter 61 exist to mitigate the potential harm to the spouses and their children caused by the process of legal dissolution of marriage. So the first legal threshold question is whether the divorce is causing a party any harm. If not, the analysis as to whether to give alimony to one party or the other ends right there. If it is causing one of the parties harm, then the next question is, does the party the court is deciding should pay alimony have sufficient resources to mitigate that harm? Alright, so the first question, is it causing any harm? If yes, the second question comes into play, and are there resources, as in financial resources, to mitigate that harm? The determination of alimony is something that we say is within the discretion of the court. This means the court must ultimately decide if there's a need and an ability to pay. That is not a statutory factor, instead that is something that stems from case law. For example, the case of Canacaris versus Canacaris from 1980. It's a Florida Supreme Court case. And we're going to talk about Canacaris a lot in this lecture series, as well as in the next lecture series on equitable distribution. It's a very important case. The court looks to whether there is an ability and a need. The determination of alimony is, as I pointed out, at the discretion of the court. And with the court's discretion, there is a wide latitude. Now we're going to learn that Chapter 61 of the Statutes of Florida provide for some specific areas that the court will look to in practicing its discretion as to whether or not to award alimony. Now recognize that people can appeal an award of alimony only based on abuse of discretion. So the court must abuse its discretion. It must have gone too far in looking at the facts and making its decision so far to have abused its discretion. This would be the trial court. From case law, we also learn that the appellate court doesn't normally second guess the decisions of the trial court where discretion is involved. And that decision of a court to look at it and decide that it shouldn't be upheld, an appeals court that is, means the appeals court looks to the standard that no reasonable man would take the view adopted by the trial court. Again, this rule of law of how discretion is looked at by the appellate court comes from the case of Canacaris versus Canacaris, that Florida Supreme Court case. The Canacaris case actually was monumental in Florida because it changed the alimony laws and how they are viewed today. Alimony can be waived by mutual consent, however, of both parties. That has nothing to do with Canacaris. It just is an important note. And the other thing important is that the court has to make written findings regarding the 10 factors of the statutes. And this means the court has to write in the final judgment its findings from the evidence. This is how the appeals court has something to look at to see if the trial court, in awarding alimony or not awarding alimony, or too much or too little, whatever the case is, has abused its discretion. All right, so this is a good amount of information to kind of understand how alimony is awarded, and also how the appeals court can look at the situation if there is an appeal as to an alimony award. So what does the court look at? Well, this slide shows the alimony statute in Florida as it is in 2013. Of course, that may change in another legislative session, but as of this recording, this is what the alimony statute looks like. And also, as I've noted earlier, in Florida, we look at child support with this real clean mathematical formula. However, in alimony, it's not a clean and easy mathematical formula. The trial court can look to a lot of different standards, and those standards are outlined right here in this slide from the statutes. I've highlighted the subsection of the statute that covers the financial resources of the marital assets, that is, the one that's in red here, the financial resources of each party, including the non-marital and the marital assets and liabilities distributed to each. I've highlighted that to emphasize to you that the courts will first decide how the property, that is the assets of the parties, will be divided between them, and how the liabilities, debts, that's what liabilities are, will be divided between the parties. They make that decision first, and then they do the alimony decision. Most books, for whatever reason, like this book by Lupino and Miller, cover alimony first, and in Florida, it's clearly the second decision after determining the division of property and debt. We'll cover it in Chapter 6. We'll go in the same order as the textbook. So that is the alimony statute in Florida. Now, we've talked about this already in the previous lecture, the previous section 2 of this lecture series. There are core concepts. First of all, that major question, is there a need to mitigate harm done to one of the parties as a result of this dissolution of marriage? And the second question is there need on one party's part, the person you're trying to mitigate the damages of, and is there an ability to pay? So is the person who is being asked to pay alimony, do they have the money to do it? And that's the core concept of an award. The first, you can't even look to alimony, the reasons why, until we have the core concepts understood. And that's, again, why in Florida they wait to do alimony after the property settlement. Because a property settlement can change things drastically. If one party gets a lot of debts and another party gets a lot of assets, that means that someone has to look at that from that standpoint and see that those assets and liabilities will clearly, either if you get a lot of assets, you're going to have more ability to pay. If you get a lot of debt, you're going to have less ability to pay. If you get a lot of assets and you're seeking alimony, you may not need alimony because you have plenty of assets, cash, paid for home, or whatever the outcome is of the property distribution. So that's how it works. That's why the court starts with the need and ability to pay concept. Now, need and ability are both based on present circumstances. Recall that in the second section of this segment of this lecture series, I told you about the court, how it looks to the present circumstances, and I used the context of how a person who's getting a divorce may already be cohabitating with another person already. And so those present circumstances are how the court determines if there is an ability to pay. And so goes the same story where it comes to need. No speculation can be had of much in the future because we're looking closely at past earnings. And there are also situations where a person is intentionally unemployed and the other party claims that they're thwarting or trying to avoid paying alimony. And the same thing can happen with the intentionally unemployed requestor of alimony. And in order to get an award, I've limited my work. I've gone to work part-time. I've quit my job. This is real-world stuff that happens. So this is the core concepts a little more placed into a little bit more of the real world and given some examples of how those core concepts of need and ability to pay work. Now, I also told you that the statutes of the past were very punishment related. And when we switched to the no-fault divorce criteria, two things changed that. One was the gender-specific nature of alimony being for women. And, if the husband could prove adultery on the part of the wife, then he wouldn't owe her any money for alimony and wouldn't have to give her any property. Of course, society and the laws have changed in such a way that those types of statutes are not any longer in effect. But the court can look to the conduct of the parties in determining alimony in Florida. But think about the fact that this is not necessarily a punishment statute. Instead, it goes to whether there was harm. And remember, that was the larger foundational test that has to be answered. Yes, there is harm to one of these parties as a result of this divorce. And that harm can come from such things as adultery. It can have great harm on a person. And so can spousal abuse. It can have great harm on a person. As such, conduct of the parties is included in the statutes about how to, and whether to award alimony or not, because of that situation of mitigating the damages when there has been harm. So the primary aspects of alimony. Well, this is important. Attorneys are looking at the need for alimony and the ability to pay when they're analyzing the client's case. And another big piece of the analysis that the lawyers are looking at is what kind of needs need to be fulfilled by alimony. So what is the purpose of the alimony? Is it to make a person whole again, or get a person out there and working again, or is it that this person can't work anymore, so it needs to? So again, the type of alimony that we're going to talk about in the next couple of slides is reliant on the primary aspects of what is the purpose, the duration of the marriage. Florida statutes actually give guidance as to the duration of the marriage and how long or what type of alimony can be awarded. So ironically, the duration of the marriage is part of the legal test that the lawyers are looking at. And what the Florida statute, or what the Florida legislature did, was provided these three types of marriage: short-term, moderate-term, long-term. And they define these types of marriages, and as we'll see in the next set of slides, that helps the court determine what type of alimony to award. Now, notice that this is something that limits the court's discretion and probably results in fewer appeals in some cases. So the duration of the marriage is a primary aspect, along with purpose, of alimony. Modification. Modification is something that may need to happen in some cases. So what we mean by modification is if the court awards an award today, and can the person that receives the award or the person that's paying the alimony award ever go back to court and say, I can't do this anymore, or I need more money, or I need less money, which is unlikely, but or the person receiving the alimony, one of the payer is saying, should have less money. Things are better for that person. So some types of alimony, as we're going to learn in the next set of slides, are modifiable, and some are not. Now, the other thing the lawyer wants to do in looking out for the client's best interests is, can it be terminated? Will the obligation ever end? If it ends in some way, then my client, who's receiver, is going to have a lot of problems because he or she doesn't work anymore. He or she is disabled. He or she is retired. He or she, whatever, all kinds of reasons. We look to, will it terminate at any time? Will that obligation to pay the support terminate at some point in the future? And so those are the 4 primary aspects of alimony. And so it is part of the legal analysis that goes on in the attorney's office and the attorney's head, trying to figure out what can I do that's in the best interest of my client. All right, this ends segment 3, I think. Yeah, segment 3 of the lecture series. And the next one is 4, and we're going to cover the types of alimony and expand on these areas of the primary aspects of purpose, duration of marriage, modification, and termination, get a bird's eye view of that.